Back in 2012, the combined opposition used its one-seat majority in the National Assembly and slashed the budget estimates of that year by over $21 billion. The government moved to the courts and they secured a preliminary ruling from the Chief Justice, which clearly states that the opposition, or the Parliament for that matter, has no authority to reduce the estimates. Um, However, the monies were replenished, but in 2013, again, the opposition moved and cut the budget, this time over $30 billion, prompting a return to the courts for a final ruling from the Chief Justice. The Chief Justice ruled today, Wednesday, January 29, and joining me in the studio this evening on Political Scope is the Honorable Attorney General and the Minister of Legal Affairs, Anil Nandalal. Minister, welcome to the program.
Thank you very much and good evening, viewers.
The Chief Justice ruled, like I just indicated today, on the budget cuts. The case which have been running for maybe almost 2 years. It's been in the court running with various challenges and all sorts of things happening over that process, that period. Tell us a little, just background a little in terms of this case, its origin, and what prompted the government to move to the court. Apart from the actual cuts, legally, what prompted the government?
Well, you will recall during the budget debates of 2012, when we were in the Committee of Supply, a motion or two motions were moved by Mr. Kemraj Ramjatan and I believe Mr. Carl Greenidge, by which they sought to, and in fact inflicted several cuts on the national estimates presented by the Minister of Finance. The Speaker then offered an opportunity for all sides to address him on the question whether the estimates can be cut or not by the opposition. And since then, that's early 2012, I presented to the National Assembly copious and cogent arguments supported by the Constitution, supported by case law authorities, and supported by text writers from various jurisdictions across the globe, all of which suggest that the National Assembly, meaning the opposition in the National Assembly, have no power to inflict a reduction of the national estimates presented by the finance minister. More so, that they cannot substitute their own estimate and use their majority vote to pass that estimate instead of the estimates of the finance minister, since the Constitution says clearly that the responsibility for the presentation of national estimates is that of the finance minister, and the doctrine of separation of powers resides that responsibility in the executive, and therefore the legislature, which is the National Assembly, which is part of the legislature, cannot arrogate unto itself a power which the Constitution has resided with the executive, and by using mere votes in the National Assembly, hijack that power from the executive and seek to exercise it. Also, I addressed the National Assembly on what powers the opposition in the National Assembly have in relation to the national estimates. And I outlined then that they have a power of approval or a power to withhold their approval. They have no power outside of that narrow parameters. And that is stated in the Constitution itself. So those were the arguments which I and other members of the government in the National Assembly canvassed then. And I, as Attorney General, sought to persuade the Speaker to disallow the motion. and persuade the opposition to withdraw the motion, that if that should they proceed to effect those cuts, they would be violating the Constitution and they would be abrogating the doctrine of separation of powers. Of course, all my arguments then fell on deaf ears, and we had no choice, the government that is, but to proceed to seek recourse in the courts, because that is where you go when any organ of state violates the law of the land or acts in a manner that is unconstitutional. And that is where we have been since. I recall distinctly that when I filed these proceedings, I was the subject of tremendous public criticisms, both in the parliament and outside of the parliament, that I don't know what I'm doing. People never heard that parliament is taken to court, that the parliament is sued, and the parliament is sued by its own attorney general. And you heard arguments like I am trampling upon the sovereignty of the parliament, and that parliament, as a lawmaking institution, can act how it feels. And, a whole host of criticisms were leveled against me. Well, all those have been now put to rest. And this judgment, which was delivered today, has vindicated my position, which I held and which the government has held for the last 2 years, in every public utterance which we have made in this matter, and on every argument which arose in the National Assembly in this matter over the last 2 years.
It has been a long road in terms of this case. All the time spent invested in appearances in court, putting forward arguments, appeals, who should appear in court and who shouldn't appear, and so forth. The Chief Justice ruled today that the National Assembly has no authority, or it's unconstitutional for the National Assembly to reduce the estimates presented by the representative of the executive, who happens to be the finance minister. Like you indicated, things went in your favor. But tell us a little about the actual ruling, and maybe a little about the process leading up to this ruling, the case.
Well, let me deal with the ruling first. The ruling addresses several salient matters. Firstly, it confirms, as I predicted earlier, in almost every material respect, with the earlier ruling, the interim ruling, or the preliminary ruling. Recall that the opposition contention then, when that ruling came out, that they are not going to be bound by it, that it is merely a preliminary ruling, and they felt incredulously, I must say, and irrationally, that they can disregard that ruling, and somehow that that ruling has no force, and they were calling upon us to have a final ruling, as they did in the Rohi's matter. Recall when I challenged in the court their gag order on Minister Rohi, I got from the court a preliminary ruling as well. They claim that they did not understand that ruling. They claim that it is merely a preliminary ruling, and somehow, inexplicably, they are not bound by it, because the law is clear. Whether a ruling is preliminary or final, it is binding upon any person that it affects. And unless and until it is set aside, it remains a ruling from a court that must be respected. But they invent all these adventurous arguments to justify their disregard for the court. On both occasions, both in Minister Rohi's case, I went back to the court and I got the final ruling, which confirmed the interim ruling. Here again, the Chief Justice has confirmed his interim ruling, but more importantly, he has amplified this in this ruling and dealt with several other matters, which obviously transpired in the interregnum between the interim ruling and the final ruling. Firstly, he dealt with what is the role of standing orders. Recall that the opposition argued that the standing orders permit them to cut. And the Speaker, though I argued against it in the Parliament, overruled me and ruled that the standing orders permit the Parliament to cut, the National Assembly rather, to cut the national estimates. I, the Chief Justice has dealt with that matter, and it's simple. Standing orders are rules of procedure for the internal running of the National Assembly. They are not laws. They are not published in the official gazette. They do not require the assent of the president. So they don't have the force of law. They are simply internal rules that the National Assembly creates and acts to govern themselves. So it is not, the standing orders cannot confer a power. All it does is regulates procedure. Legal powers are conferred by law or by the Constitution. And it is the Constitution that confers powers on the Minister of Finance, and it is the Constitution that confers powers on the opposition in the National Assembly in relation to the estimates, a power to approve or withholding of their approval. And most importantly, if any law conflicts with the Constitution prevails, and that law automatically becomes unconstitutional and null and void and unlawful. More so, something which doesn't have the force of law, that is, an internal regulation like the standing orders. If that collides with the Constitution, obviously, and a fortiori, the Constitution must prevail. And that is simply what the Chief Justice ruled, that if the standing orders provide for the opposition to cut the national estimate, the standing order is simply unconstitutional and unlawful, because the Constitution that created the National Assembly has not given it that power, and no legislation has given it that power. So that is a fundamental point that has been addressed comprehensively here. Also, what has been addressed is, as I said before, the power of the National Assembly in terms of budget estimates. And this is what the Chief Justice ruled in the final aspects of his ruling. That the power of the National Assembly is limited to giving or withholding its approval for ministers' estimates when those estimates are laid before the National Assembly. And before that, he rules that they have no power to reduce those estimates. Then another important point that the Chief Justice raised and addressed is who can be parties to these proceedings. Recall there was a ruling which, in essence, excised from the proceedings defendant Mr. David Granger and Dr. Ashley Singh. These two defendants were essentially struck out from the proceedings by the Chief Justice, whereby the Chief Justice followed a clause in the Constitution which says that no action shall be brought against a member. No civil, Article 172 of the Constitution reads, no civil or criminal proceedings may be instituted against any member of the National Assembly for words spoken before or written in report to the Assembly, or for anything brought by way of petition, bill, etc., etc. No civil or criminal proceedings may be brought. Right? So the Chief Justice interpreted that, and I agree correctly, as a prohibition against suit in relation to a member of the National Assembly. It is I who instituted these proceedings and named these defendants. And the Chief Justice essentially has said that I am wrong. Unfortunately, Mr. David Granger's lawyer interprets that, or lawyers interpret that somehow as a defeat of theirs, and they have appealed that. And they lost that appeal as well, as, you know, everyone is aware. So What is important is that all these legal issues are now being settled. It is correct that we have never had this type of parliamentary configuration before, and therefore litigation of this type has never arisen in our country before. And everyone is learning, or everyone, um, you know, trying to deal with all these legal issues that are arising. But this judgment, I dare say, has, in a great way, has addressed many of the gray areas out there and has given guidance for the future conduct of the National Assembly. The Chief Justice, before he read out his judgment, expressed the view from the bench that though this matter deals with the 2012 budget, obviously the principles which he has adumbrated here are principles of law that will guide and ought to guide future budgets. So if you don't have a power to cut the 2012 budget,
You can't cut it.
you cannot have a power to cut the 2014 budget unless we change the constitution to give you some additional power which you now don't have. So I am hoping that we will not be visited with the ordeal of the opposition, disregarding the clear final ruling of the Chief Justice of the country and proceeding to once again attempt and purport to cut the national estimates. Because again, they will demonstrate to this nation, as I've been saying since the beginning of the 10th Parliament, that they are prone and they have this proclivity and propensity to violate the law of the land, to violate the Constitution, and to use their votes in the National Assembly to bulldoze parliamentary process and procedure. Because that's what they have been doing.
Because I was about to ask you, though, because already there are indications that the 2014 budget may not will be cut. There was already that indication. But as it relates to Mr. Granger and Dr. Singh, that appeal, that hasn't been closed. And looking at what the APNU is saying, in essence, is that the Chief Justice, who said he's going to send that matter to the full court to be dealt with, while he said that he sent it to the full court to be dealt with, he still came back and gave a ruling even before that matter is adjourned.
I have seen a document which purports to emanate from a partnership of national unity.
This is what was said at the press conference today.
And this was obviously distributed. This is from their letterhead. This is a horrible and very hurried piece of writing. Obviously, someone in haste wrote this because there are so many inaccuracies contained in this release. Firstly, when the Chief Justice struck out the leader of the opposition and Dr. Ashni Singh from the proceedings before him, he did not have to, but on his own volition, he stayed the case before him to facilitate the appeal, an appeal being heard and determined, because Mr. Williams and his battery of lawyers who appeared for the leader of the opposition indicated that they want to appeal. Let me repeat that. The Chief Justice on his own volition agreed to stay his hands and put the budget cut case on hold, I suppose out of courtesy, because there was no legal reason for him to do so, and allow Mr. Granger's lawyer to pursue the avenue of an appeal against the Chief Justice ruling which struck him out. That procedure which they employed to appeal that ruling lasted nearly 5 months. At the end of that process, they lost that appeal. The full court ruled against them. The Chief Justice then proceeded to render his final ruling. A court can only be forced to stop hearing a matter or from not proceeding to hear and conclude a matter if another court orders that court to do so. We have no court order here from any court which prohibits the Chief Justice from moving forward. The Chief Justice, as I said, voluntarily waited for 4 months. They went to the full court, they filed whatever appeal that they filed, and they lost again. So on what basis should the Chief Justice continue to wait until what? They want to appeal the full court decision to another court? So I who filed the case must wait until they continue to lose, going up? There is no obligation on me as the Attorney General and as the person who filed these proceedings to await that.
But Mr. Ramjitan indicated too that his intentions are to appeal the Chief Justice's ruling today. Will that in any way impact, let's say, the 2014 budget? Should there, let's say, the appeal is done, will it impact?
No, a ruling from a judge before it is put on hold has to be so ordered by another court, either of equal but more so of superior jurisdiction. So Mr. Ramjatan's indication of an intention to file an appeal does not in any way put the Chief Justice's ruling on hold. In any event, the Chief Justice did not order anything to be done. The Chief Justice declared what the law is, and you don't get a stay of a declaratory order. The Chief Justice has not ordered anyone to do anything. He simply has declared, in accordance with the Constitution, that the opposition in the National Assembly have no power to cut the national estimates presented by the Minister of Finance. But that's all that he has done.
But I remember the argument came up, I think it was in 2013, during the budget, and there was this whole interpretation of whether the Chief Justice was giving a ruling per se that the National Assembly must respect, or is it him just interpreting the Constitution or his interpretation? Remember that whole argument came
all
up?
of that are machinations and are intended to influence the mind of the untutored. Every person who has a fleeting knowledge and acquaintance with the law, knowledge of and acquaintance with the law, knows that a ruling from a court, unless and until it is set aside, whether it is interim or whether it is final, it must be obeyed. That is one. Two, that the court, this High Court of the Supreme Court of Judicature, is the only institution in the country that has the power to interpret and declare the Constitution of Guyana and what it says and what it doesn't say. And then if you disagree with that ruling of that High Court, then you go to the Court of Appeal and then the Caribbean Court of Justice. Parliament does not have a power of declaration, a power to declare provisions of the Constitution. And when the court declares what the Constitution says, that is final and binding on every agency of state, including the President and including the Parliament. So no one can arrogate unto themselves some special power and responsibility that they can interpret the Constitution by themselves and disregard what the court's interpretation is. The court is the final arbiter on matters of law in our legal system.
We have to wrap this up, but before I want to ask: Should the opposition go to the National Assembly for the 2014 budget, bearing this ruling in mind, and cut? What are the possible actions that could be taken?
Well, you have the situation where the Speaker would be put in quite an invidious position, because there are large part of this judgment that ought to guide the Speaker and must guide the Speaker. because it is this judgment that declares what the final position is in relation to motions which can be filed in the National Assembly. The Speaker, on repeated occasions, has said openly and publicly while he's seated on the bench that he has some power of review over what transpires. So, in his power of review, he has to ensure that the Constitution is not violated. The National Assembly is a creature of the Constitution. The National Assembly is bound by the Constitution. And all that the court is doing as the final arbiter and as the constitutional interpreter of that very document, all it is doing is interpreting the Constitution. If it is wrong, then the legal system provides a method by which that wrong can be rectified. But it is not open to any agency or person or authority to flout what is the final pronouncement coming from the court of law on matters of law and the Constitution. All are bound, including the Speaker and including the executive and including the judiciary itself, by what the judiciary declares to be the Constitution and what it declares to be the intention of the framers of the Constitution and what it interprets to be the law of the land.
Finally, before we go, though, throughout the entire process of this court proceedings, we heard from you and we heard from Mr. Basil Williams. So, Mr. Basil Williams, the only two persons who were representing the government in your case, and what are the other lawyers, if they are saying about?
No, there has been quite a huge constellation of stars in this matter. Appearing for the Speaker were Mr. Roysdale Ford, Mr. Kemraj Ramjatan, Mr. Nigel Hughes, Mr. Christopher Ram. Appearing for Mr. David Granger were Mr. Rex McKay, Senior Counsel, Mr. Saisna Ryan, Senior Counsel, Mr. Basil Williams, Mrs. Deborah Usman Baka, Mr. Robert Corbin, Mr. Joseph Harmon, Mrs. Glassford, Mr. James Bond, Mr. Llewellyn John. So it's quite an impressive lineup of lawyers that appeared for the Speaker and the Leader of the Opposition.
What are the arguments, quickly before we wrap up, put forward by them? Because you haven't heard them much. What were their arguments as it relates to?
Their arguments simply their arguments were that they had a power to cut. I don't know where they get the power from. I suppose they were contending that they got the power from the standing orders. But I don't know that the standing orders can give you a power which the Constitution does not give you, and the Constitution doesn't say that you have. Standing orders can never override the Constitution. It's not even law.
Minister, I want to thank you very much for joining me this evening. Of course, before we go, we've been looking at political scope. Just a quick recap, the cuts to the 2012 national budget that was challenged in the court. There was a preliminary ruling saying that the National Assembly cannot cut the budget. It was repeated in 2013, and today, Wednesday, January 29, the Chief Justice acting Ian Chang gave his final ruling, and he ruled that the National Assembly can only approve or withhold approval of the national budget, but it cannot reduce the estimates. So I want to thank you very much again for joining us, and Attorney General, I want to thank you.
Thank you very much.